hosted by CHRGJ and the Climate Litigation Accelerator, or CLX. My name is Arpita Kodiveri, and I'm an affiliated at CLX. CLX is a collaborative initiative that strives to speed and scale up action in the context of the climate emergency. It achieves this through a four-pronged approach. Namely, it's engaging with academic research and publication, trying to tease out innovative legal approaches given the climate emergency. It's engaging in actively looking at online education and capacity building, legal advocacy and litigation, particularly with forging meaningful partnerships across different geographies and working on very exciting cases. So do check out the website, you'll get more information there. And one of the most integral parts of this program is that it anchors a global community of practice, which is a platform which engages activists, researchers, and scholars who are actively addressing the question of the climate emergency. And today's webinar, in some ways, is an extension of that particular initiative. Because every month, there's a monthly strategic webinar where we take on pressing issues and really do a deep dive into unpacking some of the interesting parts of it. Today's webinar is looking at the rights turn in biodiversity litigation. So since 2015, we've seen a proliferation of cases adopting the rights-based framework to address both biodiversity loss and climate change. So in today's webinar, what we're going to try and unpack is what are the similarities in terms of the trends across the rights turn, both in climate litigation and in biodiversity litigation, but particularly focusing on biodiversity litigation. To address this rather complex and difficult question, we have an eminent pair of panelists. Cesar Rodriguez Garavito, who's the co-director at CHRGJ and the director of CLX, and David Boyd, who's the UN Special Rapporteur on Human Rights and the Environment. He also has extensive experience in trying to understand the intersection of the loss of biodiversity and its impact on human rights. Before I turn it over to the panelists, just a quick note that the panelists will speak for 30 minutes and we will be taking questions. So do use the Q&A feature to send in your questions. And the first part of the webinar, which is open for the public, is for 45 minutes, after which it'll be a closed door meeting with the members of the community of practice. If you're interested to learn more about the community of practice, do go to the website and contact us. So I'll hand it over now to Cesar and David.
David, you want to go first?
Sure, Cesar. we didn't really choreograph this too much, but I'll say a few things and then you can jump in and correct me or add to what I've said. First of all, thanks for the opportunity to join you here. I really admire the CLX program and all that it's doing. And I think most of the people on the call are probably quite familiar with the rights-based turn in climate litigation. You know, and we can really trace this back to roughly 2006 when the Inuit filed their groundbreaking petition with the Inter-American Commission. I think that was almost like the equivalent of patient zero, if you will, in terms of rights-based climate litigation. And then since then, we've seen really a proliferation, which is well tracked by the Sabin Center in their climate change litigation database. I think there are now upwards of 50 or 60 cases where human rights are being used at the heart of climate change cases, both nationally and internationally. So of course, you have the leading international cases that are before the UN Human Rights Committee, which is the Torres Strait Islanders case. You have the case of Greta Thunberg et al., which is before the Committee on the Rights of the Child. You have the Portuguese youth case at the European Court of Human Rights, as well as the Swiss grandmother's case, which looks like it's headed for the European Court of Human Rights. And I'm sure you've discussed all of those cases in other sessions here. One thing that I did just in advance of this webinar was to Google the phrase rights-based climate litigation. And on Google, you get over 2,000 hits for that phrase. I then Googled the phrase rights-based biodiversity litigation and got 0 hits. So I think that's a really telling indication. And if we look back at the last 5 or 6 years of rights-based climate litigation, we can see that there are a combination of factors which I think are really being critical to its emergence, its evolution, and in many ways its success. And those factors and this is just a preliminary assessment, but those factors are the strong scientific background that's provided by the reports of the Intergovernmental Panel on Climate Change, and then the fusion of environmental law and human rights law. As you know, Cesar and colleagues, the Achilles heel of international environmental law is that there simply are no mechanisms for accountability. So for example, under the Framework Convention on Climate Change, there are no mechanisms to hold states accountable to the commitments they've made. There were no accountability mechanisms in the Kyoto Protocol. There are no accountability mechanisms in the Paris Accord. So international environmental law suffers from this enforcement and compliance weakness, which is being addressed through the really innovative fusion of international environmental law and human rights law. And that combination has proven it's almost like alchemy. When you add those two things together, you can produce accountability. And that's what we saw, of course, in the Urgenda decision was that very productive mixture of climate science, environmental law, international environmental law, and human rights law, resulting in that groundbreaking decision of the Supreme Court of the Netherlands. And the same thing in the Future Generations case in Colombia, which I'm sure that Cesar will speak more about. And so this is well documented by academics in the climate change setting, right? You have the rights-based turn in climate litigation article by Peel and Osofsky, which has already been cited in more than 80 other academic journals, and really kind of lays out the lay of the land. But when we turn to the biodiversity side of things, I think it's much less developed. And as I mentioned the just the fact there are no hits on Google for that phrase, rights-based biodiversity litigation, and there's no clear patient zero on the biodiversity side. There's nothing parallel to the Inuit petition. But that's not to say there hasn't been any biodiversity litigation that is rights-based. In fact, using the human right to a healthy environment, there has been a lot of litigation in countries around the world, focused, I would say, in Latin America. So you have countries like Costa Rica, where Article 50 of the Costa Rican Constitution since 1994 has said very clearly that everyone has the right to a healthy and ecologically balanced environment. So that's a human right. And it has been used in literally dozens of cases to produce outcomes that are beneficial for biodiversity. So famous cases that have stopped logging in the critical habitat of scarlet macaws, an endangered bird species. Cases that have stopped the construction of a major tourism development on a beachfront because that was critical habitat for nesting endangered sea turtles. Case from the Constitutional Court of Costa Rica that stopped the practice of shark finning. And so these are really cases where human rights, the right to a healthy environment, are being used to protect nature, protect biodiversity. And I think we have cases from Colombia as well, cases from other Latin American countries, but it's not well documented. So I think there are cases from the Philippines where Article 16 of the Constitution provides the right to a healthy and ecologically sound environment. There are definitely cases from Mexico, and I'd actually like to just quote, if I may, a case from Mexico, because it's really interesting. So Mexico has the right to a healthy environment in Article 4 of its Constitution. And recently there was a case that went to the Supreme Court of Mexico regarding a major tourism development that was proposed right in a mangrove ecosystem. So it would have damaged the biological diversity that's so rich in mangrove ecosystems. And in this case, the Mexico Supreme Court of Justice agreed that the project would violate the right to a healthy environment, ordered construction of the project to be stopped and the mangrove forest to be restored. But what the court said in that case was really interesting, and so I'm just going to read a brief passage from it. The court said that the right to a healthy environment in Article 4 of the Mexican Constitution actually has two dimensions. The first dimension, and this is the quote, the first dimension considers the objective intrinsic value of nature, regardless of the services it provides to society and human rights. And the second recognizes the anthropocentric value of nature and its relationship to the realization of other human rights. Correspondingly, the transgression of either of these two dimensions of the human right to a healthy environment results in a violation of this right. Now, that's really a kind of a fascinating approach to the right to a healthy environment. And it's actually one that has been used in at least 10 cases in Colombia by the Supreme Court of Colombia and the Constitutional Court of Colombia, in cases dealing with the protection of rivers from mining, in the cases dealing with national parks, maintaining their integrity. And I think one critically important piece of jurisprudence in this rights-based turn in biodiversity litigation is the advisory opinion of the Inter-American Court in 2017, which was also talking about what are the dimensions of the right to a healthy environment. And in that really groundbreaking advisory opinion, the Inter-American Court said something very similar, that what distinguishes the right to a healthy environment from all other human rights is that it recognizes the vital interest, the rights that relate to forests, oceans, rivers, and other ecosystems. So that critical opinion, I think, is something that can be used not only in Latin America, but globally in rights-based biodiversity litigation. And so I think we're really at an exciting point in time here where these cases are emerging, but there's not yet the kind of strategic thinking that's gone into rights-based climate litigation. And so I'm hopeful that this webinar today will actually enable all of us, or some of us, to start thinking about strategic litigation in the biodiversity sense that mirrors what's already emerging in terms of rights-based climate litigation. And we have the same key elements. We have the report now from the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services. We have the Convention on Biological Diversity, and we have human rights law. And when we combine these things, I think we have a very powerful recipe for using the law to address the global biodiversity crisis. So that's just kind of some introductory thoughts, and I'll pass the microphone over to my good friend Cesar to build on that.
Thank you, David. We hadn't coordinated the order of appearance, but we had coordinated the idea. And I should say that this is part of a new study that David and I are collaborating on, trying to contribute precisely the type of knowledge that's missing and that other people are also contributing to providing, meaning understanding the roots, the norms, emerging norms, and also the gaps in the usage of human rights language, norms, and venues to protect biodiversity around the world. So the reason why we started with a parallel with climate litigation is because David and I and many others, like Jackie Peel, of course, and Harusovsky, looked at the trend of the rights turn in climate litigation early on. I've just concluded a study of the universe of rights-based climate cases, and the count is at 66 at the moment. And what one can spot there in talking to litigants and activists and analysts who have been part of this trend is that the turning point in climate litigation happened around 2015, and it had to do not only with, of course, some landmark lawsuits like Urgenda, but also with non-legal developments that converged on making the issue of the violation of human rights caused by climate change very prominent in domestic and international jurisdictions and international negotiations. So taking a page from what that study that I finished shows us about climate litigation, I would say that there are at least 3 streams that converge on this norms cascade. And I'm using here a term coined by Catherine Sicking and Martha Fenimore that shows how international norms on human rights or other governance issues come about and pick up momentum thanks to a convergence of transnational and national factors. One key factor in the case of climate litigation, of course, was the Paris Agreement and the partial overlap with the more urgent tone in the IPCC report, especially in the famous 2018 1.5 degrees of global warming report. That, together with the evidence of extreme weather events, created kind of literally, and this is probably not the best metaphor here because it speaks of sad development, but perfect storm of that activists and scholars who had been advocating for the rights climate connection for a long time. David alluded already to the 2005 Inuit pioneer petition before the Inter-American Commission. That's where those norm entrepreneurs, as the international scholars, international relations scholars would call them, found receptive ears in international negotiations and in domestic courts, importantly. So the streams that I would argue have converged to produce this, growing cascade. We're not there yet, as David mentioned. There are very few identified cases that one can include kind of in a table of rights-based biodiversity litigation, which doesn't mean that they're not out there, but they haven't been systematically studied as such, which is exactly what we're doing in our study that started recently. But there's at least 3 streams that one can anticipate are converging towards the rights-based biodiversity cascade. One is what the former UN rapporteur John Knox has called the greening of human rights. So the use of existing human rights mechanisms, be it right to health, right to life, to litigate cases that protect, say, key ecosystems whose loss or whose deterioration directly affects human health or human life. Right? Then there is the second route that, of course, David has made a huge contribution to, which is the use of the right to a healthy environment. Right, the specific right that gets invoked and that has been recognized in most constitutions or legislations around the world, and that gets mobilized to protect, say, species. And this is how, in the very early stage of our study, we have identified a number of cases in Latin America in which activists and litigants focus on a species, right? And through the protection of that species, ultimately seek to protect the whole ecosystem. So this is not exactly the patient zero search, but it is the kind of the species zero search, right? It's a way, for example, a type of bear in the Andean region that's present in those ecosystems that are abundant in water, right? So protecting that particular species in turn protects water sources and in turn protects the whole ecosystem. And finally, there is the non-anthropocentric route that David also alluded to, which is rights of nature or cases that are also increasing in number. Some of us have been following some of them, and David, of course, has a book on that idea. And this is a growing trend and an interesting one because, of course, it adds to the other 2 streams and potentially expands the impact and the scope of biodiversity-based litigation. I'll end by saying that one can anticipate that the recent Dasgupta review that came out, of course, in the UK may have a catalytic impact on this trend. It could be one of those turning points because even cost-benefit analysts, cost-benefit analysis judges and courts that would not be very amenable to considering, say, eco-centric arguments might be persuaded by cost and benefit-based arguments to protect ecosystems, right? Of course, there's a lot of debate about the political and the intellectual value of putting a price tag on nature, but one can anticipate that more than one litigant will be using and leveraging the knowledge coming out of that review to push for protection of biodiversity using a combination of human rights and cost-benefit analysis arguments.
Thank you so much, David and Cesar. Just to get us started in the Q&A, one of the questions that came to mind as I heard both of you discuss was there is a lot of lessons that can be drawn from the rights-based framing of climate litigation. So I was wondering if you could tease out from your study, what, apart from these three streams, if there's some other emerging ideas and specific cases that you've come across. And do you actually foresee the packaging of climate litigation along with biodiversity? So do you kind of see them coming together as one particular case, as two different asks?
Well, I think actually Cesar should answer that question, Arpi, because a case that he worked on in Colombia really, I think, is probably the most clear example of how you can use a rights-based approach to address climate change and biodiversity in one piece of litigation. So Cesar, why don't you talk about the future generations case, my friend?
Happy to, but in general, there was already a question in the chat box here about the distinction and the overlap between climate and biodiversity litigation that I think is at the center of our nascent study, and also at the center of this discussion. So one thing that one can also anticipate is that climate litigants or climate focused organizations will be looking at biodiversity litigation as a means to advance climate action, right? Because there's so much overlap. I'm to speak to David's comment, for instance, in ongoing studies in the Amazon basin. I'm part of a group of experts that are drafting a report on the situation of the Amazon from different angles: political economy, climate, biodiversity, and so on, and whose report will be out in the second semester of this year. And one can see that the loss of biodiversity, the loss of huge chunks of forest, say in Brazil or Guyana or Ecuador or Peru, is already, and there's strong evidence coming out of the most notable scientists in that panel, from their studies, that there is local global warming going on, meaning that this is what one of them calls the other climate change, meaning that the loss of forest coverage, say in the state of Pará in Brazil, has made for considerably warmer temperatures at the local level. So the impact is local. So if you want to act against the deleterious effects of global warming in the state of Pará, in Brazilian Amazon, one route you may choose to activate is to fight the loss of forest coverage and on biodiversity grounds. So there's a lot of overlap. Of course, the overlap is not perfect, but there will probably be a lot of cross-fertilization between these two lines of activism and litigation. One case that illustrates this potential convergence is the one that David alluded to, that the Justicia in Colombia has been litigating for a number of years now. I had the privilege of being part of the initial effort. And in that case, the Supreme Court of Colombia ruled in favor of 25 young plaintiffs who had sued the Colombian government on the basis that the government had not delivered on its promise to cut down deforestation to net zero by 2020, as per the government's promises in Paris and elsewhere. So that it was filed mostly on climate change grounds, but undoubtedly it has had an impact not only in terms of mobilizing the public opinion discussion about the Amazon, including its biodiversity, but also more broadly exemplifies the potential convergence, overlap between these two lines of work.
Thanks, Cesar. And if I could just add to that, you mentioned the Amazon, and there are cases ongoing in Brazil, which is the heartland of the Amazon, that are attempting to use Article 225 of the Brazilian Constitution, which is the right to a healthy environment, in a climate change context to strengthen or to force the Brazilian government to take climate action that's more ambitious than what they're currently doing. But Article 225 of the Brazilian Constitution not only includes the right to a healthy environment, it includes a provision that says the government of Brazil must stop all activities that contribute to extinction. And so I feel like there's a tremendous opportunity in Brazil for rights-based biodiversity litigation to try and bring about an end to deforestation in the Amazon as one kind of prototypical example. I didn't say when I was giving my introductory remarks, there is a lot of biodiversity litigation that happens all over the world, but Cesar and I are really focusing on a very small subset of that, which is the rights-based biodiversity litigation. So I wanted to clarify that, because for example, in the United States, there's decades of really quite effective litigation under the US Endangered Species Act. Similarly, in Canada, EcoJustice has filed numerous lawsuits using the Canadian Species at Risk Act. There's lots of litigation in Europe that uses the nature directives, the European Union's nature directives, to try and protect biodiversity. And so our focus in our research project, which is really in an early stage, is really what's this subset of rights-based biodiversity litigation, and does it have transformative potential? Because that's what we're looking for at this point in time. Given the climate crisis, the biodiversity crisis, the global environmental crisis, we need to scale up our impact, and our hope is that rights-based biodiversity litigation may be a pathway in that direction. It's not going to be easy, though. I think it's important to make that clear at the outset. And there are already some bad precedents out there. So for example, in the European Court of Human Rights, where the first climate cases are just making their way through that system with great hope, the European Court has ruled repeatedly that there is no right to nature protection under the European Convention on Human Rights. So in a case called Kirtatos versus Greece, for example, the court made that clear. I think that those European court decisions on nature protection are probably wrong in that they betray a failure to understand the science that, in fact, harm to nature does have harm on individual human beings. And that's the challenge that is one of the challenges we will face in this area of rights-based biodiversity litigation, which we haven't talked about yet today, but which a lot of people still don't understand, that there is actually a connection between human rights and biodiversity loss. And this manifests itself in many different ways. You know, there's good scientific studies from India, for example, that shows that coastal communities where there are intact mangrove forests are statistically less likely to suffer deaths during a cyclone than communities where those mangrove forests have been damaged or destroyed. Biodiversity loss has impacts on the right to health, on the right to food, on the right to a healthy environment. And I've chronicled these to the best of my ability in a recent report to the United Nations General Assembly, and we'll put a link to that report in the chat box as well. So I think that continuing to deepen our understanding of the impact of biodiversity loss on specific human rights is a critical piece of work that needs to parallel the legal work going forward.
Exciting. So we have quite a few questions from the audience. So what I'm going to do is get to a few of them. So a couple of questions highlighting how does one look at the subject of the litigation in terms of biodiversity loss? How do you pinpoint corporations or states? And another question about, can corporations be held accountable? And this is a question to both of you.
Yeah, that's an excellent question, and one that speaks to the gaps so far of climate litigation. In the survey that I conducted of climate litigation based on human rights arguments, 90%, 90+%, 91% of cases have been filed against states. Of course, human rights being a state-centric legal apparatus, that's not entirely surprising. But when you look at the evidence of climate harm, meaning the fact that major corporate actors, in the case of climate, fossil fuel corporations, the carbon majors, are among the key actors that have driven global warming, well, the gap is striking. There are a number of organizations, of course, Greenpeace and the Filipino organizations that filed the petition before the Filipino Human Rights Commission have tried to address precisely that gap, and we're waiting for the Commission to issue its report anytime now, in the case against the 19 carbon majors. There is nothing that we have found yet, but we're still looking. So actually, one way to send the questions back to the audience is, if you know of any case of this type, please reach out to us because we're actively surveying the kind of the lay of the land. I see with the one type of case that I would see emerging relatively soon, and CLX here at NYU has been exploring this with partners in various regions, is legal pressure against nodes in global commodity chains, corporations in global commodity chains that drive major forms of biodiversity loss. So think beef, large beef producers in Brazil, right? Exporting to Europe. So going up that chain and putting different types of pressure on buyers, on intermediaries, and on producers themselves is, I think, a promising avenue that some organizations are exploring, and we're part of that collective effort. So no case that at least I know of. Maybe David knows of such a case, but a lot of possibilities to do that in a way that would be more centrally concerned with corporate responsibility than the climate litigation based on human rights has been so far.
Yeah, thank you for that, Cesar. And I agree. I don't know of any cases where corporations have been the target of rights-based biodiversity litigation. But turning back to the state for a moment, I mean, you know, rights-based biodiversity litigation is going to face some of the same challenges as rights-based climate litigation, right? Establishing causation, questions related to attribution. But if we look at the way that the international environmental legal framework has been used in the rights-based climate change litigation, you can envision something similar in the rights-based biodiversity litigation. So let me make that more tangible. So in the rights-based climate litigation, for example, in the Urgenda case, what was really helpful there was the commitments that the government of the Netherlands had made to reduce greenhouse gas emissions, their commitment in that regard. And if we look at the analogous types of commitments made by states under the UN Convention on Biological Diversity, think about the Aichi targets. So I know the Aichi targets have now passed because the end date was 2020, but between 2010 and 2020, states committed to a wide range of targets, some of which could quite easily be seen as binding let me back up a minute. The Aichi biodiversity targets, which parties to the Convention on Biodiversity agreed to in 2010, were not legally binding targets in the sense that they were in terms of international environmental law. So you couldn't go to court and say Canada has violated its commitments under the Aichi targets to protect 17% of its land by 2020. That would be a non-starter because there's not a valid legal basis there. But when you bring human rights into the picture, the way that human rights have been brought into the picture in climate change, could you not say that based on my right to a healthy environment and my government's commitment to protect 17% of land by 2020, that they actually could be held to that commitment? And that a court would say to the government of Canada, as the Supreme Court of the Netherlands said to the Dutch government, not you must reduce greenhouse gas emissions more quickly, but you must protect land more quickly in order to meet your 2020 target and protect the biological diversity in Canada. So we're now in the process of establishing new targets under the post-2020 global biodiversity framework. There's a high ambition coalition led by Costa Rica and France, which is pushing very hard for the protection of 30% of all lands and waters by 2030. And I think there's a good chance that that target will be incorporated in the post-2020 global biodiversity framework. And I think that's an area that's ripe for this type of rights-based biodiversity litigation to ensure that that's not just another political commitment that states make and then break. You know, as people probably know, not one of the many Aichi targets that were agreed to in 2010 was fully met by 2020. And again, that's because of the lack of enforcement mechanisms, the lack of compliance mechanisms, which produce a lack of accountability. So I think that this is one example of where a rights-based turn in biodiversity litigation could be really productive.
The next question is about what kinds of remedies do you see rights-based biodiversity litigation asking for? Would it be using some of the biodiversity international agreements?
Yeah, that's a key question, of course, because we may get perfect rulings from courts, and if they're not implemented or monitored, well, the impact on the ground is going to be limited. I think, again, this is an area in which lessons from climate litigation and also other forms of litigation in the human rights field, like socioeconomic rights litigation, come in handy, right? So I would just flag a couple of ideas based on past work on climate and socioeconomic rights. So one is precisely what litigants in the two Brazilian cases that before the Supreme Court of Brazil that David alluded to are trying to get from the court, meaning some sort of structural injunction that lives up to the scale of the entity that needs to be protected, right? One major source of asymmetries and mismatches in human rights litigation and the structural problems that it tries to address is that oftentimes, because of the tradition of individual responsibility and backward-looking responsibility, most of the time cases point to someone individually being held accountable for a human rights violation that affects another individual or a community, right? But even the members of that community usually need to be identified as in individual terms. So that logic of individual responsibility tends to be at odds with the kind of ecosystemic nature of the harm and the collective nature of the violations, for example, of the rights of a whole indigenous community in a key ecosystem like the Amazon or elsewhere. So one way that litigants have tried to address this mismatch and kind of fill the gap is by asking courts to issue remedies that protect whole ecosystems, right? And then the second mechanism entails the court playing some sort of supervisory jurisdiction role, right? Meaning monitoring the implementation of its own rulings through mechanisms such as public hearings, in which governments need to come back to the court, report on progress after a certain period, say a year, and above and beyond the kind of the instrumental impact of those orders, meaning that governments, especially if they care and they're politically accountable to public opinion, they will try to up their game in terms of protection of those ecosystems in between those public hearings. But even if they don't, then those hearings and those opportunities for monitoring tend to offer occasions for civil society actors to come together and put pressure on the media through monitoring on the ground, through scientific monitoring, and so on. So this is about asking for remedies that A, are at the scale of the harm, and B, that keep the pressure on the state or the corporation under examination.
Yeah, there's one thing that Cesar's answer to that question reminded me of that we actually haven't discussed, and which I think is going to be a tricky one for us to deal with, and that is the issue of Indigenous rights. Indigenous rights, and many Indigenous peoples use litigation as one of the tools in their toolbox to assert and advance their rights. And in a lot of cases, Indigenous peoples are using litigation to protect their lands, their waters, their territories with, I would say, they would not frame it as rights-based biodiversity litigation. That wouldn't be their framing, but that would be the outcome, because we have clear and compelling scientific evidence that where the titles and tenures of Indigenous people are recognized, the lands that they are owning and managing have much better biodiversity outcomes than comparable lands that are not owned and managed by Indigenous people. So Cesar and I haven't even discussed that, which shows how early on in our research process we are. But I think that there's a really interesting thread there. I mean, Indigenous people obviously care profoundly about the biological diversity of their territories, and to the extent that they're using litigation to protect their territories, that is effectively rights-based biodiversity litigation, perhaps by a different name.
There's an interesting question here about what are the risks of conducting rights-based climate or biodiversity litigation? Do you see it sort of furthering the perpetration of human rights violations, for example, local farmers versus Indigenous communities? So how do you address this, and what kind of methodology would you use?
Yeah, I think that's a really important question, RP, because in the past there have clearly been examples, for example, in the biodiversity context, where states have created new national parks or other types of protected areas, and in so doing have evicted Indigenous peoples or traditional communities from their homelands, and that simply cannot continue in the 21st century. So that's part of taking a rights-based approach to both climate change and biodiversity issues, not so much from a litigation perspective, but just ensuring that all of the actions we take to address climate change take a rights-based approach. All of the actions that we undertake to address the decline of biodiversity take a rights-based approach, and make sure that we don't, in the process of trying to address one set of human rights violations, create another set of human rights violations. Obviously, that's the last thing that we want to do, but we do have to be cautious, in the field of climate change. So I've talked about how parks have created human rights violations in the past. In the climate change context, states are building hydroelectric projects that have a similar effect of displacing Indigenous people and local communities, and that we just have to come up with more intelligent solutions than substituting one set of problems for another.
Yeah, I agree. I don't have anything substantive to add to what David just said, but it occurs to me that because we're coming to a close soon, that since many of the questions relate to parallels between climate change litigation and biodiversity litigation and speak to issues of climate litigation, that I would share, we will post this and other links in the CHRGJ CLX website soon, along with the video from this conversation. But there's a blog series here, and I'm sending the link, in which a number of litigants and analysts from around the world have been discussing strategic issues of climate rights-based litigation that I think can be oftentimes extrapolated, can be usefully mobilized in the debate on biodiversity litigation.
All right, I think that brings us up to our time. So thank you, Cesar, thank you, David. And I guess now we'll be proceeding to the closed group discussion. Thank you, everyone.